Morning, everyone. Hopefully you all enjoy a bit of Hall of Notes in the morning. I must say I am a sucker for a bit of Hall of Notes, so you can blame me for that track. And hopefully it wasn't too much of an indication of our industry of how we treat personal data. Morning to everyone. Welcome to, I think, the 34th weekly IAB webinar. We are nearly there. We've got one more next week. For those who haven't met me, I'm Gay Leroy and I'm incredibly lucky to be the CEO of the IAB. I think the audience, we've got half our inner circle and some newbies as well. So welcome to those who haven't joined us before. If you've missed any of the previous webinars, you've got a treat in store. You've got 34 hours of entertainment over the Christmas break. So please feel free. I think Tiff's going to drop a link to the previous webinars in the chat box, so you can all get started on those. Normally in December, we run a fun event called our Crystal Ball event, which is a live event with different industry experts giving their view on the year that's been and the year that's coming. This year we're going to do a little bit different. We're still going to have a fair bit of fun on what some may consider a dry topic. I'm sure the panelists today do not think of it that way, but we're going to focus on a topic that's incredibly important for us in the industry, particularly next year in Australia. So we've had a lot of, I guess, focus on identity from a technical point of view this year. Next year is definitely going to be focused on the consumer side of things and privacy regulation. Last couple of years, I guess, in local and overseas market, there's been a lot of discussion on consumer privacy and data governance. We've had GDPR come into market a couple of years back. Some of you may remember changes to the Australian data breach laws and a lot of, I guess, flagging of changes and reform for the Australian Privacy Act. And in particular, a lot of the issues that were brought up in the ACCC DPI report, which I'm sure all of you have read, that 600-page report in detail. The process now has officially kicked off. So in October, a 90-page, quite light for a government report, the Attorney General released a 90-page issues paper posing 68 questions, I think, from memory, on different areas of privacy reform, identity, and how we move forward as an industry. So that had a 4-week period for people to get back with feedback on that issues paper, but don't fear, that's not our last chance of getting involved as an industry and making sure that we find the right solutions that work for industry and consumers. So 2021 will see a discussion paper released early next year. So the IAB will be keeping the media and marketing community informed in how we can get involved, what we need to know, and what you need to do, more importantly. So today we have 3 brilliant minds joining us, 4, but 3 subject matter experts who are going to do a 10-minute pitch to an extent on what privacy Nirvana or privacy hell could look like in terms of regulation reform. It's meant to be lighthearted. I haven't seen the presentation, so I'm slightly excited and slightly terrified at the same time. They are just a huge TNC conditions here. They are not IAB endorsed ideas. We are IAB curious at this point to see what they've got for us, but really excited to see their ideas. After each of them give their pitch, Paul McIntyre is going to interrogate, explore their ideas, and you are welcome to pop some questions in the Q&A box. We do have a tight time frame, but please jump some questions in there. If we don't get through all of them today, we'll ensure that any follow-up pieces go on those topics. So the 3 people that we have for you to explore their ideas, first up we're going to have Anna Johnston, who is Principal of Salinger Privacy. Anna's a long-term privacy lover, I would say. So as well as running Salinger Privacy, previously she's been the Deputy New South Wales Privacy Commissioner, among other roles in her career. And it's going to be followed by Peter. Many of you may know Peter. He does some work for us, some briefings for our members. is now principal of Data Synergies, his own company that definitely needs more staff because there are so many privacy bits and pieces going on at the moment that he's incredibly busy man. So, and Peter's look, had so many roles I can't even go. Have a look at his LinkedIn profile, but he's industry expert. And then from the industry side, Peter and Anna are both lawyers who've worked sort of within government, academia, and worked very closely with industry. But Anna Milicevic, who's again a close friend of the IAB, locally and globally, is from the industry, one of the very, very early entrepreneurs in the digital data space, and now runs a consultancy called Sparrow Advisor, working with really top tier companies on their digital strategies, but with a particular love of I guess, using data in the right way. So both from a monetization point of view and handling it in a careful way. So 3 different angles there. So I'm going to keep quiet now. I'm going to hand over to Anna, and I'll come back at the end. So enjoy. Anna, over to you.
Thank you, Gay. Let me just see if we can start the screen sharing. Okay, can you see my slides?
Perfect.
Fantastic, thanks Gay. Well, good morning everyone, and thank you Gay and JJ in particular for inviting me to join your end of year wrap up webinar and a bit of crystal ball gazing hopefully. So in order to prepare for this privacy nirvana or privacy hell topic, I started by Googling Nirvana, which gave me Smells Like Teen Spirit, which if you are too young and hip to know this, was a grunge rock song named after a brand of deodorant, which seems kind of appropriate for a discussion about marketing. So that was Nirvana. Then I looked up hell, which led me to Dante's 9 Circles of Hell. Now, having only been vaguely aware of what Dante was about, since he was not quite as popular as Nirvana was in my day, I checked him out to discover that in Dante's imagining, each circle of hell is assigned to a different type of sinner who then suffers their own brand of punishments. So hell progresses from the unbaptized and the pagans who are nonetheless virtuous via gluttons and adulterers to murderers and then traitors. I can only assume that lawyers and advertising executives are allocated somewhere in the middle there. So this got me to thinking, how does God know who should go into which circle of hell? Obviously, the big man upstairs has some pretty serious surveillance and data analytics capabilities if he can segment his audience this well. And then that got me to thinking about the other big guy who knows something about surveillance and the delivery of personalized messaging. After all, they say, he knows if you've been sleeping, he knows when you're awake, he knows if you've been bad or good, so be good for goodness sake. Now, depending on whether you've been bad or good this year, you might receive a good Privacy Act or a bad Privacy Act next year. So I wanted to tell you what I believe a pro-privacy Privacy Act might look like. But then I'm going to leave it up to you to decide if that's your idea of privacy nirvana or your idea of privacy hell. So one of the themes running through this latest review of the Privacy Act is the need to ensure that Australia's privacy laws empower consumers to protect their data while also allowing businesses to engage with consumers online. Of particular concern is the need to ensure that the Australian Privacy Act is brought into closer alignment with Europe's law, the GDPR, so that Australia could possibly, finally, secure an adequacy decision from the European Commission. And now this would open up more possibilities for trade in personal information, because if we had what's known as an adequacy ruling, then personal information could be transferred from Europe to Australia more easily. Now, to date, that adequacy ruling has escaped Australia. They have asked but not received in the past, primarily because of a number of carve-outs from the Act's coverage of the private sector, including exemptions for small business, employee records, political parties, and media organisations. So first on my Christmas wish list is for all of those exemptions to be scrapped, to really expand out the material scope of the organisations regulated by the Privacy Act in the first place, so that we in Australia could have a world-class privacy law. Now, given where this review started with the ACCC's Digital Platforms Inquiry, we should also expect the government to focus very much on targeted advertising, personalised content, and the role of online identifiers in particular in facilitating the digital advertising ecosystem. But at the moment, it's not always clear whether cookies or other online identifiers or the information shared within the ad tech industry is even considered personal information as defined and as regulated by the Privacy Act. So next on my wish list is to rethink the scope of the Act by expanding out that definition of personal information. So the definition of personal information in Australian law is a threshold issue, or in fact in all privacy and data protection laws. If something doesn't meet the definition of personal information or personal data, depending which law you're talking about, then it's simply not regulated at all. So through the current definition in Australia, the Privacy Act regulates conduct only when a person is identifiable or reasonably identifiable. However, in my view, privacy harms can also arise from what I call individuation, which is the ability to single out a person from the crowd so that they can be tracked or profiled or contacted or located and then subject to some kind of action or decision that impacts them, excuse me, even if the individual's identity is not known. Now, this poses a really fundamental challenge to current privacy legal frameworks. If you think about it, from the digital breadcrumbs we shed from our mobile phones to the patterns of behaviour we exhibit online when we browse, click, comment, share, like, we can be tracked. And from there we can be profiled and finally targeted, all without the party doing the tracking, profiling or targeting needing to know precisely who we are in a legal sense. We are just a collection of attributes. In my view, the digital environment has turned on its head the assumption that identifiability, in the sense of knowing a person's identity in a legal sense, is the only way in which someone can suffer a privacy harm. I would argue that individuation can potentially lead to privacy harms and therefore must be anticipated by more modern privacy laws as well. So a rethink of the threshold definition of personal information in order to explicitly include online identifiers and technical data such as metadata, and a new definition which encompasses the idea of individuation as well as identifiability could lead to really significant improvements in the quality of privacy protections for Australians. Now, that might seem like a really radical change, but it would actually be in keeping with global trends. Newer laws like the California Consumer Privacy Act have already moved in this direction. Under the CCPA, information that simply links to a consumer via a device is within scope for its definition of personal information. The full identification of the consumer is not necessary. And given the CCPA's introduction of do not sell buttons, and the European Parliament and European privacy regulators moving on ad tech, and Google's Chrome browser phasing out third-party cookies by 2022, and Apple's operating system being updated to implement opt-in only for tracking users across different apps and websites, well, there's already plenty happening to nudge the online behavioural advertising industry towards a more privacy protective opt-in model. So in my view, strengthening the Australian Privacy Act's definition of personal information would be in line with achieving those same objectives, but in a technology neutral and industry neutral way. Another pet topic of mine is the role of transparency, such as notice and consent. Now, while I am all for more transparency, it is only effective as a form of privacy protection if it's meaningful. And much of the time, let's face it, we don't really have a choice in what is happening with our data. And in those cases where we do have a choice, most of the time we don't have the time or energy or the bargaining power or the understanding of the nature of the risks in front of us to make properly informed decisions. So another possible reform on my wish list is a reduction in the Privacy Act's reliance on the transparency model of privacy regulation, instead moving towards stricter limits on collection, use and disclosure. The issues paper for the review of the Act canvasses alternative models, such as GDPR-type overarching fairness tests and the Canadian idea of no-go zones for certain types of data flows. The Australian privacy regulator, the OAIC, has already expressed its preference for something like an overarching fairness test. What might that mean for the advertising industry in particular? Quite possibly some of the more intrusive methods of profiling customers would be off the table, as well as advertising or personalised messaging, which could lead to obvious harms. So I'm thinking here about practices, for example, which target vulnerable individuals, such as people with a mental illness or a gambling addiction. Another area that might be considered under a broad banner of fairness could relate to children. In its report on customer loyalty schemes, the ACCC noted that multiple submissions requested that children should not be tracked, profiled, subject to marketing or monetised. And finally, I would love to see an increased penalties for breaches, a statutory tort for serious invasions of privacy, and reforms to deliver improved access to justice. This could include a direct right of action for individuals with a complaint about a breach of a privacy principle. At the moment, complainants can only go to the privacy regulator, the OAIC, whose backlog of complaints creates delays and can operate as a barrier to resolution of complaints. Whereas the ability to take a complaint to a tribunal or court with the power to order compensation, as happens already under New South Wales and Victorian state privacy laws, well, that could see a meaningful improvement in access to justice for those people keen to have their day in court. I also believe a direct right of action could make companies and government agencies more mindful about protecting privacy in the first place. So that's my vision of what a more privacy protective version of the Privacy Act could look like, which is certainly what I would like to see in my Christmas stocking this year. But as I said before, I will leave it to you to decide whether my vision of good privacy law is your idea of Nirvana or hell. If you would like to know more about some of these law reform proposals, the Salinger Privacy submission to the Act Review is published on our website, along with our regular blogs that delve into many of these topics in more detail. I would like to thank you for your attention, and now I will hand over rather to Peter Leonard for his view.
Hi everyone. I'm intending not to use slides this morning because I'm still on my anti-PowerPoint campaign. What I'd like to do is just pick up a few of Anna's points and really focus in on where Anna and I differ and where we agree. And it's fair to say that I do have important differences in views to what Anna has said, although I probably agree with 75% of what she had to say. The key points of difference, I think, between us are in the vision of how to get to Nirvana, and indeed, because of our different view of how to get there, I think we probably are defining a hell in itself. So let me explain what I mean by that. I think my vision of hell in privacy reform is doubling down on notice and consent in the way that the ACCC's Digital Platforms Inquiry report invites us and now the Attorney General's Department to do. And that is really cranking up the requirements around express consent and broadening out the definition of personal information to include, amongst other things, online tracking code, even in circumstances where online tracking code is handled in accordance with good privacy practices. And I think that if we go down that road, we are simply continuing the fiction that users should be expected to self-manage their privacy settings through reading privacy notices and or deciding whether or not to give consents. That has a number of problems, one being that much data now is collected in our surveillance society in circumstances where users are not even aware that data about them is being collected, or simply where it is unreasonable to expect that they should exercise understanding, should have understanding and exercise responsibility for what information they hand over and what they don't. Now, I'm not saying that notice and consent should go out the window. I'm saying that notice and consent should be reserved for those situations where it really is the appropriate tool to govern how and when personal information is being collected and used. I think that we can take some of the best elements of GDPR, as for example, the Canadians have done in their recent bill, and as we can see in the latest variant of Californian regulation, the CPRA, I think it's called, which was just passed in principle as part of the presidential and congressional elections in the US. We can take some of those best elements and build them into our regime and roll back and control notice and consent requirements for when notice and consent is really appropriate. Now, I'm not advocating a free-for-all in online behavioural advertising or targeting or profiling of users. Indeed, just the opposite. I am endorsing the suggestion that Anna made and the Privacy Commissioner has made around adoption of a fairness or reasonableness standard, such as the Canadians have done and are proposing to do again in their new legislation. I think we should have no-go zones around, for example, targeting of children, such as the Indian legislature is proposing in its draft data protection bill. I think that we should strengthen the legitimate interests or reasonable business interests exceptions so that we actually can ensure that notice is not required of things that people would look at and say, well, of course, somebody's going to use it for those purposes. I don't need to know that. I don't need to consent to that. And please don't bury me in notices that I don't need to read in order for me to not be able to find the bits that I really do need to read. So in other words, I think there is a role for legitimate interests or a reasonable business purposes exception. It's got to be appropriately controlled and directed. Singapore has recently spent quite some time working through what appropriate controls might look like. The new Californian bill that I mentioned before, the CPRA, does the same. So we have good precedents in that space to look at and to adapt into our legislation. Let me be very clear though that I do not believe that we should be significantly extending the definition of personal information to include online identifiers. And again, by saying that, I am not suggesting that there should be a free-for-all around use of online identifiers. To the contrary, I think that where an entity is enabling other entities to use online identifiers, the entity that is enabling that should be responsible for what goes on in that data ecosystem, simply because they enable others to do things even if they elect not to do them themselves. So I think, to be frank, we need to clean up the advertising data ecosystem, and the industry won't have credibility to say to the regulators that we can regulate an advertising data ecosystem unless industry accepts that good governance is an essential attribute of privacy compliance. So I do think that our new legislation needs to recognise the difference between pseudonymisation and properly controlled data governance for analytics purposes, including for audience segmentation, and to draw a clear distinction between audience segmentation and unacceptable individual level profiling. And I think that's a very important distinction that we need to help the regulators understand. So I don't agree with Anna, for example, that all profiling, which would include audience segmentation, should be effectively regulated as a use of personal information. So look, there are some points of difference in our views. We agree with each other much more than we disagree with each other, and I hope that we can continue this very useful debate. And with that, my time has expired, so I'll very happily hand over to Anna.
Thank you, Peter. I am going to flip us back to PowerPoint World and talk you through a couple of really mainly nightmare scenarios that are stemming from my local market here in the US, kind of things that you shouldn't follow at all if you can. And then shifting into a much more positive situation on what an ideal type of privacy regulation could look like. So this is me. I've spent the better part of the past 2 decades in different facets of high-tech management. For the better part of the last decade, I was very deep on digital data. I was the head of product for the company that Adobe bought to enter their, to start creating their marketing suite. I've also worked on the analytics side of data, identity side of data, and over the course of the past 5 years have advised brands, technology companies, and publishers and content creators on how to put all of this together in a meaningful way for consumers. You'll often see me speaking for media outlets, both trade and more mainstream. So I look at this challenge around privacy really from the lens of market dominance first. And I know we talk a lot about how large the US market is, but I want to give you a really strong visual of exactly how large, or rather how much larger it is than other markets here. So if we look at just 2019, projected spending in 2020, obviously treat that with an asterisk because of the pandemic, but we are talking about the US market that really dwarfs subsequent markets where we're somewhere in the 305 billion Australian dollars range in total media ad spending. The second market following us, China, is less than half. And then you need to roll up 6.5 subsequent markets to get to parity with the US. If you plonked the entire EU, it would fall somewhere just short of China's #2 slot. So it would be ranked #3. And that all depends on whose numbers you look at, because sometimes the EU includes just EU states and sometimes includes EU plus a few. I wanted to sketch out the kind of different privacy frameworks that we've seen emerge in different countries. So on the one hand side of privacy permissiveness, let's say, it's the comprehensive regulatory framework that you're seeing represented in legislation like GDPR in the EU. On the absolute opposite of this spectrum is the US approach, which is minimal and very sector-specific regulation. So I think both of my predecessors have mentioned things like restricting access and how data is collected from children. So we do have a law like that called the COPPA, and it doesn't really go far enough. Then China, as the another ginormous market here, had initially implemented a very similar approach to the US one, with very minimal, again, sector-specific, sometimes vertical-specific regulation. But they are starting to revisit that approach as of late and are moving towards a much more comprehensive regulatory framework that is coming, not quite as detailed as GDPR, but it's definitely moving in that direction as opposed to the rather laissez-faire approach that we see in the US. I've put Australia closer to the comprehensive regulatory framework, much more similar to GDPR than what we have on the other side of the spectrum in the US. So you're somewhere here. And if we looked at what a terrible hell scenario in privacy looks like, you can already tell that I'm going to talk a lot about the US market here, because I do think that we've flubbed this, even though we have outsized responsibility to nail it and really implement it well, because not only is our market very large, a lot of the companies that everyone across the world is working on come from the US or are headquartered in the US. So really the main caveat is that what works for the US market doesn't necessarily work for other markets. And that is sometimes harder to see when you're in a non-US market, just because we're so ginormous. We're the largest global consumer market. We have about 328 million people now, represent about 25% of the entire world's household consumption, and just have silly levels of GDP in the trillions, which to me will never not be an incredibly silly number. So what's happening in our market is stratification and solidification in the top end between very large platforms like Google, Facebook, and Amazon, who between the three of them are commanding 68% of the overall digital ad revenue share in the past year. And as you can see from the slide, this has only gotten more and more concentrated year over year. So there's the top three, and then there's a huge gap, and then there's kind of everybody else. So we're effectively fighting this battle between the walled gardens and the open internet that we used to enjoy in the past. And I think that's something that's definitely playing out in the Australian market right now too. So we have two competing challenges that both touch on privacy. One is this big tech is too big argument that has been going around in favor of regulation. And it really boils down to, we've gotten these large platforms to be so dominant that we should now apply some type of regulatory activity to make them less dominant, but we haven't quite figured out what that should look like. We've had the first antitrust lawsuit filed just recently. We're expecting more similar lawsuits filed imminently, and we're still not sure which way the new administration is going to go, but the DOJ, the Department of Justice, has given indication that they are ready to file several subsequent lawsuits any day now. This is exacerbated by the fact that we have no federal level data protection at all, never mind digital data related, but no personal data related really. We've had some attempts around specific data sets, like I mentioned, COPA, that addresses kids. There are some vertical specific ones, for example, around what government agencies can do, like the Department of Motor Vehicles, the Post Office, with the personal level data, but really not much beyond something bad has happened, let's quickly do a law to fix that specific problem. And as you know, with the type of data sets that we're seeing today and the types of technology that enables joining of very disparate data sets to create pseudo identities or actual identities, not having that type of foundation is a bit like building a house without a foundation. So not the best scenario. And we're now starting to see states take individual action. California, through the CCPA, now 2 versions of it, has taken the first step. California is a very large state. If it were not part of the US, it would be the world's 5th largest economy, represents about 40 million people. And so this is a very significant step that they've taken in moving towards that comprehensive regulatory framework. So this is good and bad. The existence of state level versus federal level at the US level legislation risks effectively fracturing this single consumer market that we've created. So imagine if instead of working with just the US, you would have to work with 50 individual little states, and they all had slightly different approaches to privacy. And this would be the utmost nightmare scenario, I think, for everybody involved in the industry. Just the level of effort required for compliance would likely make a lot of collaboration pretty moot and really a non-starter. So now that I've scared you, let's talk about what this could look like on the positive side and what Nirvana could look like in this scenario. So the GDPR, the CCPA, the California Consumer Privacy Act, has 3 pillars that it revolves around. It's transparency, control, and accountability. And I like this a lot as a basis for a lot of extended frameworks. On the transparency side, you may have seen this from the IAB, whose tech lab has proposed this data transparency label, which is very similar to the food labels that you would see on food, that lists basic information around where certain data point was sourced, to what audience segments it's describing, the who, what, how, and where behind a particular data set that you're seeing. I think efforts like this can really improve data literacy on the consumer side pretty significantly, but really also on the ad buyer side and across the entire ecosystem. On the second pillar, you've seen Apple take a very active stance on declaring privacy as a fundamental right, which is a very interesting approach to outside of the realm of any legislation, really positioning yourselves as the good company when it comes to privacy in front of consumers, and essentially solving the privacy challenge in a consumer-friendly way. And then I think the most important pillar of this is really the enforcement side of it. We're starting to see first attempts at enforcing legislation, not in the US just yet. This is GDPR enforcement against large platforms that 2 years after GDPR came into effect is starting to pop up. And I see this as really the stick that needs to exist so that people would take privacy seriously. And I'll end on that note. We talk about privacy a lot, but in the consumer mind and in our collective minds, unless you're a privacy specialist, it seems like it's something fluffy and optional. And instead, I would like us to shift this conversation away from privacy and more towards data usage rights, and creating an environment in which consumers can specify what are the types of exchanges of data where they will find value, as opposed to just platforms or data aggregators or some third party achieving all of the commercial advantages of transacting with data, with consumers really having no say in how their data is packaged, used, or activated. So that's my Nirvana scenario, without really sketching in too much detail what it's going to look like. I imagine it as some platform where you can designate what you're interested in receiving and seeing, but I think we'll have to wait for the next couple of years to have this materialize as consumer awareness around privacy and data rights increases, whether through actions like Apple's or through reactions to large data breaches like I think every country has experienced lately. All right, so on that note, Paul.
Thank you, Anna. Thank you, Anna. Thank you, Peter. So we've got probably about 15 minutes to crack through universal theory and solve the world's problems. We're going to be really quickly on this one. I want to just for the audience, or firstly, I've got to do a shout out to Gay for showing her age, class, and dance moves with that track, that Private Eyes track. So anyone that's slightly older than 21 probably has never heard of it. I have, and good call, Gay. Now that bit we've got out of the way. We're going to try and get through really quickly. Sort of 4 key themes. I want to get to consumer attitudes towards privacy. It's in my mind, it's quite messy and trying to understand what they really think. We have different surveys, different studies saying different things. We'll get to that. The democratization of data, all the panelists have kind of touched on that a bit. How does industry prepare and adapt? And we'll get some thoughts from the panelists on that. And then the curveball for the 3 of you is, what's your hunch and how this may play out in terms of the Privacy Act here? So what you see needs to happen, but how do you think the government will actually go? And that's a crystal ball. We won't hold you to it, but it's a nice speculative piece. But to the first bit, I just want to, as a bit of a setup around genuinely how the public, how the individuals feel about privacy and tracking. I want to get your sense on it. The ACCC's Rod Sims, on the Google case that it's brought in the federal court on breaches to online tracking and privacy and deceptive mechanics to get user consent, and although you might be aware of that, happened in mid-year. But in that briefing, there's a media briefing that I was at with Sims, and he said this. He said, during the digital platforms inquiry, we found in our surveys that over 80% of people did not want their browsing and web crawling activity and the data generated from that to be combined with their personally identifiable information, so they could be profiled on the web or be the target of targeted ads. Our view, says Sims, is that had people been given a real choice, and this is in the Google case, had they been given a real choice, had they not been deceived, many of them would not have clicked I agree. Some internationally use the term that this is an agreement for deception. Now, there's Sims and the ACCC with its studies on public perceptions and sentiment towards privacy. You see others where it says it's okay. There's a benefit if I'm targeted. It's okay. I've got a benefit. That there's something relevant to me. And so I want to just get the sense from all of you first on where you think this sort of disparity sits, this dichotomy between different studies on consumer perceptions towards privacy. So Anna, I might start with you, given that you had something to do with privacy in a past life, just a little thing. What's your sense on the public sentiment?
So I actually don't see those two positions as opposed. If you've got most people saying, well, I want to better understand, or Rod Sims saying people should better understand what it is they're agreeing to before they click I agree, and they should be given more options. And then you've got some people saying, well, I'm fine with targeted advertising. Then that's great, as long as we're all given that option, and the people who are happy about to have their data linked and be profiled and have targeted advertising, then they get to say yes, and the rest of us get to say no. And I don't think that those two positions are actually in opposition. They're just expressing, coming at it from the same kind of angle. But I think that case and other cases kind of illustrate the problem, which is that most people don't really understand exactly what's happening or what they're being asked to agree to, may feel like they have no choice but to say I agree in order to get access to the kind of digital service or the platform that they're after. And it's extremely hard for anyone to understand, even privacy experts, to necessarily understand what the potential risks are going to be, because it's so obtuse. The risks, there's a time shifting aspect to this. I'll get the benefits now, and the risks may or may not play out in the future. And the risks will not be transparent to me. I won't know that I've seen a particular ad or not seen a particular ad, or seen something in my news feed, or been excluded from seeing something in my news feed because of, you know, my web browsing history or whatever it is, it won't be apparent to me exactly what's going on. So that's partly why it makes it extremely difficult for anyone to make informed choices. So I think we should be given the choice, but at the same time, I don't think that being given more transparency and control is in itself the solution. I think there still needs to be something like the overarching fairness framework to regulate. You know, there should be, whether it's no-go zones or whatever, some concept of activities. Certain activities just should not be allowed in the first place. And we as consumers shouldn't be put in the position of having to agree to them or being asked to agree to certain practices.
Okay, so Peter, the two things there. Do you see a tension? Is there a tension to be reconciled between public views on not wanting to be tracked and others saying that it's okay? There's that part of it, but also what Anna's talked about. I think you talked about the onus on this collection and consent and transparency. You think the onus should be on the data holder, not the user, to sort of govern what happens with the data. There's two parts of the question there, Peter, but the first one on public perceptions on privacy first and tracking. Do you buy Sims's line on the 80% don't want it?
Well, at one level, my answer is simple. I don't care what consumers think. And that's a very glib answer, but let me explain why I say it. There are two very separate fields here which keep getting confused. One is consumer protection as administered by the ACCC, and consumers are entitled not to be misled, and consumers are entitled not to be the subject of unfair contract terms. Then there is separately the issue of data privacy. And the reason the distinction is important is that increasingly data is being collected in circumstances where I'm not a consumer. I may be walking down the street and there's facial recognition cameras. I may be observed by an IoT device. I may be the subject of online tracking in circumstances where nobody knows who I am. And in all of those circumstances, data privacy law does have a role to play and to ensure that there is good and fair data governance. But let's not try and follow the Mad Hatter, I think it was, who went down the rabbit hole, or was it Alice? Anyway, whoever it was that went down that rabbit hole of notice and consent as the way to fix all of this, because all we're going to do is to create a hell of organisations papering their way to compliance. As Anna said, we do need to have a basic standard of fairness and reasonableness that applies to what organisations do and what they allow other organisations to do. And let me just quote one section from the Canadian bill that was tabled 2 weeks ago. 3 lines. An organisation may collect, use or disclose personal information only for purposes that a reasonable person would consider appropriate in the circumstances. And then it goes on to list factors to consider in determining what's appropriate in the circumstances. Then they include the sensitivity, excuse me, of the personal information, whether the purposes represent legitimate business needs of the organisation, whether there are less intrusive means of achieving those purposes at comparable cost and with comparable benefits, and whether the individual's loss of privacy is proportionate to the benefits in light of any measures, technical or otherwise, implemented by the organisation to mitigate the impact of the loss of privacy on the individual. Now, that's, you know, what is it, 20 lines in total. And if we included those 20 lines in our Act, we could fundamentally change how organisations think about privacy. And we start to get the appropriate balance between organisations demonstrating accountability and users, consumers, somehow being expected self-manage what other organisations are doing, collecting information in ways that they simply can't understand, that we can't explain to them in terms that they will understand, and that often we don't understand ourselves.
Right, and does Peter have a point there about the onus on consent and understand the user, the consumer, understanding just the complexity of what they need to be across to make an informed decision on consent, and therefore his point around the governance responsibility going to an organisation rather than on the user. What do you make of that argument?
Oh, look, I'm in complete agreement, which doesn't make for a very interesting webinar.
But I'll find something. Wait, hang about.
I have a slightly different wrench to throw in there, and that's that we've done a really bad job as an industry describing the value trade-off to consumers. So all we're doing is asking them to say yes to if they want to set cookies, and unless you know what a cookie is and what a cookie looks like, how are you going to process that? And how are you going to understand that something that you do today can potentially 5 years down the road be used by a completely different company you've never interacted with because somebody has sold your data on through several transactions? And that's where I think we're failing as advertisers to highlight all of the cool things that we could be delivering in exchange for some privacy considerations, but really failing consumers altogether in a consumer data literacy and a consumer data rights usage again perspective. And it's one of those things. You could have the best possible legislative framework, but if you don't make it understandable for consumers in a way that Apple, for example, is doing now by saying that privacy is a human right and similar very emotionally inducing language, then I don't think we're going to be quite very successful as an industry. So for me, it's less about that. I think it's clear, and I agree that the onus here really should be on companies rather than individuals. But at some point, we need to find a way to articulate the value to consumers of this data exchange. And maybe that's the reasonable person clause from the Canadian legislation.
Right, and Anna, our time is closing.
One other point there, Paul, because sure. I think we should make it before we go, and that is we've mentioned consumer protection, we've mentioned data privacy, but this debate is not only about those two things; it's also about market structure. Because if we get these settings wrong, one hell that we might create is inability for independent players in the advertising sector to be able to create audience segments and market outside the digital giants. Mm-hmm. And we do run a real risk that if we get these settings wrong, we are going to promote further concentration in the market in favour of a few global digital players. And I'm not suggesting that that's necessarily a good or a bad thing. I'm just saying,
well, I shall.
If wrong, that's where we will end up.
But that's what we're seeing in the US with the stratification where the top 25 largest companies, and really it's the top 3, then a big gap, then the rest of the 20 something.
Right, and it does get us, Anna, it does get us to this next point, which I'm conscious of time, the democratization of data. Now, I did a really interesting podcast with one of your colleagues in the US, actually, an Australian expat, Joshua Lowcock from Global Brand Safety Officer at IPG Media Brands. He says two things. Basically, if we don't regulate on data and companies and how data and how the access and scale of data, then if you don't regulate, we'll all be working for Facebook or Google in a time frame, because that is such. And he was not even being glib about it or trite. He was serious that the way the direction's going at the moment, the way that the power sits with Google, Facebook, Amazon, as we've mentioned before. So he says regulators must be very cautious about privacy legislation that just strengthens the power of the incumbents and doesn't open up the dynamics of the marketplace, which is what you're saying, Peter. And he argues that GDPR has gone that way. That's sort of been the default or the byproduct of GDPR, as it actually has consolidated power and around data to those big walled gardens. So how do we avoid that here, or what do we got to watch out for? And a little bit of contention. Anna first. If we don't do something right in and around data democratization in a business context, will you and I be working for Facebook and Google or Amazon? Is it a real threat, or a real issue, I should say, not a threat? Let's not scare everyone.
I certainly think one of the flaws in the European model of regulation is it's a combination of GDPR and the e-privacy directive, because it's the e-privacy directive that actually says something about cookies. I don't think all the cookie banners and the cookie notices and all the rest have done consumers really any good. I don't think that that's a good model. And in focusing too much on cookies, it doesn't really, it's just focusing on the methodology instead of the underlying nature of what data should be allowed to be collected and used and disclosed and what shouldn't. So I do think that the solution is not either too much focus on a particular technology, like the phasing out of cookies, or too much on a particular industry like ad tech. I think one of the strengths of the Australian approach is an industry neutral, technology neutral set of regulations that comes back to what is fair and what is reasonable, as opposed to, particular rules about cookies and walled gardens and all the rest.
Right.
Because, something like Google phasing out third-party cookies on Chrome, while at face value it might look privacy protective, it's also going to protect Google and Facebook that already have their walled gardens and already suck up so much data that they don't need cookies anymore to do it.
Well, they don't need it because they've got logged in ID data. They've got first-party data that's consent compliant. Peter, your take on that?
Yeah, I agree. And just to sort of focus in on the risk, if you make it, if you continue to build around the concept of notice and consent, almost by definition, you advantage vertically and horizontally integrated entities that can be one-stop shops in obtaining notices and consents. And that can confer unfair advantage on those entities as compared to disaggregated entities. And given that we live in a satellite economy, not California, not the USA, we need to be very careful how we regulate, because if we regulate to facilitate concentration and centralisation of control of data, it will almost invariably be against Australia's interests.
So listen, we've got 1 minute left, and I reckon Gay's going to jam my phone in a second. So I'm going to wrap two questions up with both for all three of you, and maybe give yourselves a fast talk of 30 seconds each or a minute max to do it. The first thing is to all of you, what's your hunch on how the privacy changes in this market, in the Australian market, will play out? So if you're going to be a betting person, which way would you go on where it's going to go, the direction? And as a result of that, how does this industry prepare and adapt for what could be coming? Because there's potentially systemic change going to happen here. That's sort of my setup question. So to you, Peter, first.
Well, I think the ad tech sector is the outside runner in a handicap race where the ad tech industry has partly been responsible for its own handicapping. And the horse that is way out in front, because it started at least last July, is the ACCC and its vision of what new privacy laws in Australia should look like. And unless the advertising services sector gets some bloody good jockeys and gets itself back in the race, the outcome will be whatever the ACCC tells the Attorney General they think the outcome should be.
Great point. And to your point, I would agree that the advertising industry at large has been too self-serving and too short-term self-interest for too long, and now there's a bit of karma coming, and so this is why let's get some broader perspective on things. Anna, your take on that?
I think.
Oh, Gay showed up. Watch out.
Yeah.
I heard
I'll
some
be.
criticism of our industry. I thought
I will be really quick.
We summoned you.
I think of all the topics canvassed in the issues paper, if I was a betting person, I would place money on them tinkering with the definition of personal information, coming up with a stronger definition of the essential elements for consent, and maybe the overarching fairness test. Beyond that, I'm not sure we'll see much action. How can the industry prepare? Get ready to pivot to opt-in only.
Right. Gay, if I'm allowed to ask Anna the question, or you can do it, or you take over. I'm getting out of here now.
Do the last one, and then I'll jump in.
Okay, Anna, your take. And I know it's down under and you're a long way away, but what's your sense?
Yeah, I agree with Anna. I think that's exactly what we can see from the regulatory body. What I worry about is, and Peter, you mentioned this just recently, that if you're a satellite market or a smaller market, there's only so much you can do with local legislation, especially if you are expecting to have platforms play in your market too. So any type of regulatory activity really needs to be balanced with the understanding of what the platforms will do to counter, and really what you're potentially sacrificing, which may mean that smaller, more innovative ad tech, martech companies and data companies will simply skip the Australian market and opt for other markets if they perceive the legislative environment to be too restrictive. And that's something that we've seen with GDPR when it first came into play, but it actually spewed a wave of innovation, endemic innovation from European companies that had kind of privacy built in, as opposed to just having it glommed on later and kind of trying to work, to graft it on something that wasn't really designed with privacy at the core. So that's kind of the trade-off. It might be a few very weird years, but I think it's ultimately for the best for local ecosystems especially.
Great. Gay, to you. I'm out.
Yeah, perfect. Thank you, everyone. I know we could talk about this for hours, and I think it's really essential that we start talking about this in more details. On that note, we're working very closely with Anna Johnston and Salinger Privacy to launch a training program for media and marketing professionals to actually understand the law. So it's very interesting whenever we write an article, whenever we do a webinar that has the word cookies, that has the word sort of technical solutions, the interest and appetite is about 3 or 4 times larger than when we talk about the law. We want to rectify this and make sure that everyone has a really solid understanding of where we play today. So look out for that. Look out for that next year, and we'll come back to you guys with how you can make sure that you're really at least doing the right thing now and understanding what we're building on top of. So we're really excited about launching that in February. Our last webinar of the year next week. That robot looks a little bit like how we all feel, I think. After 2020, but I'm throwing the word cookies back in there because that seems to be our clickbait Daily Mail type word for anything. So it's our last webinar of the year. We're going to give a really good update from IB locally. So Jonas Yanamaji, our tech lead, will be joined by Jordan Mitchell from IB Tech Lab and really give an overview of where we are with the different recommendations that different companies are coming through with identity solutions. So really, really nice, sharp snapshot of where we're at in the market, and making sure that we tie these two issues together a little bit more, today's webinar and the tech issues. So hopefully some of you can join us for that. Sorry we've gone over, but you'll all get a link to this recording. You'll also be able to enjoy an audio version that lovely Paul McIntyre and the MI3 guys are going to put out. So if you want to go for a jog and listen to it, that will be available next week as well. So thank you so much to all the guests. Really important topic. Thanks for delivering it in a fun way and an easy to comprehend way. Thank you all, and we'll see everyone soon.
Thanks, Gay. Clickbait Leroy.
Yeah.
Thanks, Gay.